Before the board is Department of Health versus Richard G. Schulman, PhD. Case number is 2013-02123.
Mr. McClaren, if you'll allow that. And who is Dr. Schulman?
Yes. Could you please come forward and present your, say your name for the record, please?
I'm Richard Schulman.
Both people who are.
I'm James Meyer, his legal counsel today.
Okay.
And Dr. Schulman, if you'll be sworn in.
Do you solemnly swear that testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes, I do.
I'm sorry, Mr. McClaren. Go ahead.
Thank you. The administrative complaint in this case alleges that the respondent violated section 490.009, subparagraph 1, subparagraph T of the Florida statutes by continuing to practice psychology while under a final order in a previous case that required indirect supervision of his practice. Respondent treated approximately 21 patients from on or about June 22nd, 2012 through on or about January 24th, 2013 without a board-approved supervisor in place as required by the final order in case 2011-08435. As far as service goes in this case, a copy of the administrative complaint, an explanation of the rights form, and an election of rights were sent to respondent's address of record via certified mail. On or about March 12, 2014, the department received a certified mail receipt signed by the respondent, and the respondent then failed to file an election of rights with the department or board as is established by the attached affidavits that you see in your file today. Now, the respondent had 21 days by statute for him to elect his venue of resolution pursuant to Rule 28-106.11 subparagraph 4 of the Florida Administrative Code. These are the uniform rules of procedure, and has not done so. Now, the respondent is present today, so the department would ask that you accept the investigative report to evidence for the purpose of imposing a penalty. The department asks that you find the respondent was properly served and waive the right to a formal hearing. The department asks that you adopt the findings of fact set forth in the administrative complaint. The department asks you to adopt the conclusions of law as set forth in the administrative complaint, and find that this constitutes a violation of the Practice Act.
So moved.
Hold on just one second.
Okay.
You need to break those down.
You want them? Oh, I'm sorry. We've been doing it as a unitary motion.
Yeah.
Okay.
We have.
Well, since the respondent is present with his counsel, I think it would be appropriate to ask if they have any dispute as to service.
And I would respond that we have none. I've been in discussion with Mr. Leland, and we have no disputed issues of fact.
Okay.
Thank you.
If you can do a motion then to do the service, the waiver, and the findings of fact. Do you have any dispute as to whether those findings of fact constitute a violation of the Practice Act that's alleged in the administrative complaint?
No, ma'am, we don't.
All right, then it's appropriate to go ahead and proceed with the motion as it was.
Do we hear a motion?
You had a motion.
Yeah, you moved to accept Mr. McLaren's recommendations. Do I hear a second?
Second.
All in favor say aye.
Aye.
All opposed say nay. Motion passes.
Thank you, Mr. Chairman. At this time, it would be appropriate for the board to hear from the respondent in this case.
Please proceed.
Before the respondent speaks to the board, I'd like to just clarify my role, and that is of his legal counsel. I've asked him to respond to questions to the board members today as to why it was that he did not respond in timely fashion. I'm a latecomer to the case, as the pleadings would show. The other person that was going to be here today would be his clinical supervisor, Dr. Healy. And unfortunately, he was held up at the airport due to security reasons. He was not there an hour before time, and so he was not able to be present at the board meeting this morning. However, he did fax to me a copy of a 2-page report that I'd like to read to you after my client has a chance to speak to the board. It was very important that his supervisor be here, but those are things that we could not control.
Thank you.
Thank you.
Questions from the board?
Well, again, may we at this point hear from Dr. Schulman?
Yes, exactly.
Oh, thank you. I'd like to thank the board for hearing me. And to To begin with, of course, there's no challenge to the facts of the case. And I just really want, I'm here more to apologize for not responding in a timely fashion, and to let everyone know that I've worked really hard in my supervision with Dr. Healy over the last, over 12 months. And as evidence of that, the shutting of the practice down with the board's order was a very difficult experience, but it was done in a highly ethical and sensitive manner. In consultation with Mr. Meyer, I understand the difficulties that I created by not responding in a timely fashion. And he also advised me that the recommendation of Mr. McCarron of a fine of $5,000 was halfway between $1,000 and $10,000, which the board is certainly by rule allowed to make. This creates quite an economic hardship for me, and I would ask that that fine be reduced to $3,000 so I could pay it in an expeditious manner and get back to work, because I have been unable to practice. And I would just ask the board to remember that I went 25 years without a complaint, and I thank you for listening to me.
Can you tell us were there any mitigating circumstances for why you did not respond to the complaint?
Well, I just needed to, it was a very difficult process, and I needed to think. I needed to make sense of it. And when I finally found Mr. Meyer, he kind of put me on the right track, got my, but got the legal part of this put together, and then I felt that I could come before this group and talk to you. Okay.
And the supervision is now in place?
Supervision has been in place for a year. The order was for a year, and I've completed that year with Dr. Healy, yes.
Any further questions, discussion among the board?
Well, Dr. Schulman, I'm again, would be interested in any mitigating circumstances at the beginning of all of this. It was clear you had appeared before the board.
Yes, sir.
It was very clear what the board had ordered in terms, again, of your needing to submit resumes and of potential supervisors, and until that time, not to practice. This is a fairly, and I'm looking here, board members, at page 31 of our briefing materials, and there is quite a lengthy list of patients that you saw prior to getting the supervision in place. Was there some confusion on your part? I don't understand why you proceeded when the board, with you present, had been very clear as to what its expectations were.
Well, actually, I didn't meet with the board till after all that happened. I wasn't present at the first meeting when the order came down. But that's it's maybe a reason, but not an excuse. There's no excuses. I'm not making any excuses. I was not in a good frame of mind in terms of myself, but I was also, I could say I was very concerned about the patients who, when I got back into practice, started contacting me in droves, and it was a bad decision. I'm not going to make any excuses, and I feel like, the year of supervision has helped me tremendously to get back to myself, plus the time to just think about what I really wanted in terms of my practice and my future. I don't know that's about all I can say.
I would like to respond to that,
sure,
just somewhat indirectly. Dr. Schulman asked me to become involved in this case. As you know, I'm cross-trained as a lawyer and as a psychologist, and I said to him basically, an order is an order. End of subject. The order meant what it said, and that means cease and desist. And maybe that's from my criminal law background, but the fact was, he convinced me that one of the concerns that he had was for suicidal patients. He had one or two that were on the cusp of whether or not they would take care of, that he would be allowed to see them for I call a sense of closure. Now, that doesn't excuse the fact the board said cease and desist and stop your practice. But that was one of the reasons that I agreed with him as representing this council. Does not take away the sting of the fact that he violated the order.
My only comment was that after reviewing all this information, it seemed like the violation was pretty flagrant, and I didn't see any mitigation in it at all.
Any further discussion? Mr. McClaren, can you?
Well, yeah, I do have one other question of Dr. Schulman. Dr. Schulman, at that point, during the initial case, I don't recollect, were you represented by counsel at that point, or were you here pro se yourself?
Well, I had my defense attorney from my criminal case was just sort of handling the paperwork, but I didn't really understand the process. He just kind of handled the paperwork and said, sign this. I'm not blaming him. I should have gotten a counsel who was like Mr. Meyer, who was much more well-versed in this process. I had just gotten out of being incarcerated, and my counsel he's a great defense attorney, and he said, "You want me to handle this?" And I said, "Sure," and it was a mistake.
Okay.
Dr. Rife, it appears that he had entered into a settlement agreement that was presented to the board at a meeting where neither he nor counsel representing him were present.
Right.
And so, and then the board had rejected or had made a counter offer that was sent
Right.
to Dr.
Yes,
Right.
now that you mentioned that, yeah.
Right.
I'm not recollecting even full extent.
So, Ms. McClaren, the recommendation is suspension and a $5,000 fine?
Mr. Chairman, the department's recommendation today is, in accordance with your guidelines, calls for suspension until compliance. And in this point, since he has obtained a board-approved supervisor and has gone through the one-year period of indirect supervision under probation, that has probably been complied with at this point.
Correct.
The department, the rest of that recommendation for penalty in your guidelines is for a fine from $1,000 to $10,000. And the department, in light of the fact that he did in fact perhaps eventually correct the error and obtain the required supervision, would be a recommended $5,000 fine. Costs which will be addressed in a separate motion. And in this case, a reprimand of the license. Particularly since, although it's not called for in the disciplinary guidelines, what is called for has already been complied with. The suspension, I don't believe under your guidelines at least, that there would be a place for the board to suspend his license stay absent an upward deviation from the guidelines. But a reprimand, the department feels, although not specifically set out in the guidelines, would be thoroughly justified in this case, particularly because he failed to respond to the administrative complaint, even though he received it personally and signed for it. It's not a matter of it coming into his office and being misplaced or being set aside or something like that. But in mitigation, he did obtain the supervision that was required in the other case, and he has gone through that apparently successfully. And again, the department would recommend, as we stated, with the exception of also including a reprimand. In this case, justified by the respondent's disregard of the administrative complaint in this case and his failure to timely comply with the requirements of the order in the prior case.
Board members, so what we're talking about is a reprimand for not responding within 21 days to the administrative complaint, and then a $5,000 fine, which is halfway between the maximum that we can impose.
Board members, if I may just, you really should not use his failure to respond as an aggravating circumstance. Everyone has the right not to respond to the board. So that's technically not an aggravating circumstance. If you do want to use the failure to timely comply with the order, I mean, that's appropriate.
Right, timely comply. That's what I was being. Thank you.
Failure to comply with the original.
Which is failure to respond, but I understand the legal language. Thank you. And which sounds reasonable to me. Any board discussion? Because I agree with Mr. Bryan that there doesn't seem to be any mitigating circumstances here.
Mr. Chairman, at this time, may I read into the record the two-page report from a supervisor, which might clarify some of that?
Would you put the microphone toward your...
Yes, I asked that...
was this, excuse me, was a report included in the I don't think I've
No,
seen this.
we expected him to be here this morning, and
Okay.
when he could not board the plane, he faxed me. I already had a copy of it, but he faxed it on his letterhead, and I have copies, written copies for each board member if that's convenient. But I just wanted the board to consider that, not as mitigating, but as a way to understand the professional behavior since he was under supervision, and why he may have decided not to respond.
I'll entertain it.
Sir,
Please proceed.
do you want written copies, or do you want
Just the oral's fine.
Okay, thank you. And this is coming from Michael Healy, PhD, dated July 23rd, addressed to the board, and he says he identifies himself as the clinical supervisor of Dr. Schulman. When Dr. Schulman approached me with the request for supervision, I did not make a quick decision. Although it was apparent that he presented with long experience, possessed good credentials, and demonstrated extensive knowledge of psychological treatment modalities, the circumstances of his probation evoked some ambivalence on my part. I was made aware of his legal problems and the information that he had not completely followed the final order of the psychology board regarding supervision. After several interviews with Dr. Schulman, I agreed to supervise him as it became clear that he fully understood my role as clinical monitor, i.e. to oversee his practice of psychology and to ensure the protection of the consumer and the profession of psychology in general. He understood that he needed to adhere to my clinical judgment when disagreements regarding patient care surfaced. He signed a contract agreeing to all the demands made of him required of a psychologist on probationary status. He cites the 456 statute. The narrative he shared underscored the important questions were the legal professional difficulties that Dr. Schulman experienced indicative of repeated patterns of behavior that would pose a danger to clients or compromise the integrity of our profession? Was the behavior that resulted in the legal consequences he experienced a manifestation of character pathology? My experience and advanced training in object relations were useful in resolving my ambivalence. I found no evidence of character pathology on the part of Dr. Schulman. After a year of weekly meetings in his office, twice a week during those quarters requiring supervision of all his cases, I have had ample opportunity to assess his clinical skills. I feel I have a well-formed understanding of his proficiency as a psychologist. Since our offices are located nearby, I could unexpectedly appear at his office and did so on several occasions to see what he was like when he was unprepared for a unscheduled visitation. He was respectful and willing to discuss clinical issues. Moreover, he consistently maintained his professionalism and demonstrated good capacity for empathy despite coping with the stress of additional sanctions by the board. Dr. Schulman is dedicated to his patients and steadfast in the philosophy of doing no harm. He held high clinical ethical standards regarding client care and safety. This was most evident in the ethical and sensitive manner in which he closed down his practice to comply with the most recent order by the board. He received supervision readily, observed boundaries, and respected the hierarchical nature of our relationship. He was able to explore transference and countertransference issues that arose in the treatment of his clients. He was non-defensive when given feedback. An ongoing review of his clinical records demonstrated that he incorporated this feedback in his clinical work. Although his charts contained all the information to meet APA standards, he worked on reorganizing them to make the clinical data more available in a systematic fashion. He also worked on integrating the intuitive qualities he demonstrated with evidence-based interventions. He complied with my request that he review the theoretical underpinnings of his therapy approaches. He's recently taken a course in the ethics of electronic communication, gaining knowledge in the use of the cell phones, emails, and the internet and social media as they might be available in his practice. Having had an entire year to observe Dr. Schulman, I feel I have a strong sense of who he is as a psychologist and professional. Without reservation, I recommend to the board reinstatement of his license, and I would be happy to provide Dr. Schulman clinical consultation as needed in the future should the board reinstate his license. However, I do not believe that it requires further indirect supervision at this point. Thank you. Signed by Dr. Healy.
Thank you, Dr. Myers.
Yes, sir.
Discussion by board members?
Mr. Hall, is Dr. Schulman still on probation?
Mr. Chairman, address that.
Is he still on probation?
My understanding is that if in the order that was in the prior, in the prior case, he was directed to be on probation, I believe, for 1 year. Now, that was the case before I started handling this court's cases. But I did look at it, and my understanding is that he was required to be on probation for 1 year, which he has now completed, albeit not in a timely fashion. So I do not believe at this point, having complied with that, I believe he still has to come back to the board and ask for probation to be terminated. But I do not believe that technically he has complied with the terms of the probation at this time, yes.
So the issue, again, of termination of the existing probation is not before us today.
Not under the terms of this administrative complaint, no. My understanding, the usual procedures in these matters are that the respondent appear before the board with his supervisor, because he could not, but...
And until that time, the indirect supervision must continue.
Should continue, that is correct, as I understand it, yes. Now, again, in this particular case, the probation was set for a period of, it's kind of both ways in the orders if you want to look at it that way. The probationary period was set for a specific term of 1 year, which he has apparently complied with. Now, in other words, I don't know whether he may still be on probation, but I don't know whether these specific reporting requirements would still be in place since the term has run on the probation.
I've turned to counsel, but I believe they would, because I believe we made it part of the final order that Dr. Schulman and Dr. Healy must both personally appear before the board before the supervision and probation can be lifted. I see Ms. King nodding her head.
You have that final order on page 64 is where it indicates that he has to appear at the last meeting of the board preceding termination of probation.
And while I appreciate the fact that Dr. Healy has been not able to board the plane and has provided us a written statement
today, I'm sorry.
Yeah, I still would like to hear from Dr. Healy directly, and so the issue of indirect supervision, I think, again, I don't believe that's really before us and won't be until at the earliest in October. Now, on the other side of the ledger, so to speak here, I did hear Mr. Meyer mention that there may well have been one or more patients dealing with issues of suicide or self-harm, and that may have had an influence on Dr. Schulman's decision to continue to see them. The other aspect of this that I would at least take into consideration is that I'm hearing Dr. Schulman make no excuse, and that he has taken responsibility directly. He has acknowledged that he made a mistake here, and for me at least, that also can be taken into consideration. I would also mention, may I, Ms. Latz, may I reference the previous original case with Dr. Schulman?
Other than just making a reference, the basis for that complaint has already been addressed by his prior final orders.
Then let me say there was a substantial fine in that case, and Dr. Schulman also, as I recollect, was incarcerated for a substantial period of time and therefore removed from any ability to practice and make any money. And so, my sense of it is that, again, Dr. Schulman is likely found himself in some difficult circumstances financially in his life. Is that correct, sir? Or?
Yes, sir.
Yeah.
And I need to take that in consideration too.
Certainly. The issue before us, though, is he failed to comply with a directive to practice only under the supervision of a board-approved supervisor. Saw these patients, whether they were suicidal or not. I'm not sure that that's a significant factor that would have been referred to somebody who would be able to handle those cases like we do with others. I agree with Dr. Wright that I think we should be amenable to a downward departure, so to speak, in the fine, maybe the $3,000 is requested, but I'm all in favor of a reprimand for not complying with the board to continue to see patients when directed not to. How does everybody else feel?
I would concur with that.
Yeah, and I'm leaning in that direction too. Again, I think $3,000 fine is still a significant amount of money. The reprimand, I believe, is a key point.
That's the key point.
Yeah.
You want to make it $2,500?
I think 3,000 sounds more comfortable for me at this point.
Had a shot.
Because again, this is not a minor issue. And,
right.
So I believe there does need to be a fine of some significance. At the same time, again, I'm aware of, based on the previous case, that Dr. Schulman has had a difficult time of it here, involving that case and the outcome of it and what that involved. And so I'm also in favor of lowering it to $3,000 and a reprimand. But I'd be interested in hearing from other board members before a formal motion to that effect is made.
No, I concur with your assessment. I think that's a good idea.
All right. Do we have to have a separate motion for the costs?
Yes, and the only other question I have is, according to your rule, the payment of that fine is within 30 days. Did you want to keep that in place, or did you want to extend the time?
Can we extend that?
It's up to
board
you.
members? 6 months?
Yes, at least 6 months. May I ask of Dr. Schulman, is 6 months going to be feasible in terms of?
I hope so, yes.
Yeah, okay.
Thank you.
Well, it'll be important, sir, if we vote in that effect for you to fully comply.
It'll be done in 6 months.
All right.
Okay. Chair will entertain a motion.
So then I will move that we issue a reprimand of his license, a $3,000 fine to be paid within 6 months.
And can we include costs in that motion, Council?
I thought that was a separate
It's
motion.
a separate motion.
Okay. All in favor say aye.
We need a second?
Second, I'm sorry. Second. Dr. Rubin seconds. All in favor say aye. Aye. All opposed say nay. The motion passes.
And if I can just clarify for the order that the issuance of the reprimand was based on the failure to timely comply with the previous order?
Correct.
Yes, ma'am.
Thank you.
Mr. Chairman, we're not quite clear as to whether or not there's going to be ongoing supervision.
There will be ongoing supervision until which time the respondent, Dr. Schulman, appears before the board with his supervisor as declared in the previous.
The very next meeting, which is in October?
That could be.
All right.
It would be best if he would file a motion or a request to have that probation terminated, and then the board would have all the information regarding the compliance with that previous final order.
That'll be done. Thank you very much. I just wanted to be clear.
Okay. At this point, the chair will entertain a motion regarding the cost.
Thank you, Mr. Chairman. The department would recommend the board that it entertain a motion to impose costs in the amount of $1,038.14. Again, the department is not requesting legal fees in this case, as they are less than $2,000. It would cost at least that much to obtain the expert review for the fees. So the department is asking for the imposition of costs in the amount of $1,038.14. Is there a time limit on that? That's up to the board. Your guidelines call for 30 days. If you wish to make it run concurrently with the fine,
that'd be acceptable to board members.
I move costs within 30 days.
Here, a second. When there's a motion on the floor, we either have to vote now saying yay or nay, or can we discuss that after a motion's been made?
You can discuss after the motion's made, just prior to the vote.
I think we should do it concurrent with the fines.
I would agree.
Okay, but we have to now vote on the motion.
I don't believe it was
she can amend her
seconded.
motion.
Can you amend the motion?
Sure.
Sure.
Amended to 6 months.
Okay. Second. Second. All in favor say aye. Aye. All opposed say no. Nay. Motion passes.
Mr. Mark, may the final or the order be emailed to you?
I would prefer a paper copy if you don't mind.
Okay.
My office is across the street from yours if you want to bring it over.
Look at it every day.
Well, one point of clarification though, is his license now ended? The suspension ended? because he has met in compliance as Mr.
Well, I
Aaron has said.
It
don't
wasn't
know if the
suspended.
license...
It was never suspended, it was in probation.
Okay, is the probation in?
Well...
The supervision remains in place.
Well, Mr. Marr, did he pay the fine and costs that were imposed by the original order? Because that's when the suspension was, that was what was
He says he
the
did.
suspension was tied to. So if he's paid those, then he shouldn't be on suspension because hopefully he was not practicing while he was on suspension. And so his license should just be on probation and will remain on probation until it's
Probation
terminated.
until the October meeting.
Well, assuming it gets terminated at that time, yes.
All right, thank you.
Is there anything else, Mr. McLaren?
Yes, sir. Mr. Chairman, I'd like to present the prosecutor's report to the board.
Thank you.
I sent an amended...
Is Dr. Schulman excused at this point?
Oh, yes.
Thank you.
For coming. Before you make your report, I'd like to relinquish this gavel over to the chair.
Thank you, sir.
Thank you, sir.
Thank you so much. Great job. Anybody needs a restroom break?
I think 10-minute break would be great.
5 minutes?
That'd be great. 10 minutes?
Well,
1.5.
did you want to let Mr. McLean give his report so then he can...
Oh, so you can-
Oh, yes. Yeah.